Please be seated. Yeah. You ready? Okay. For the record, both assistant state attorneys are present, both defense counsel and Mr. Sievers. State's ready.
Yes, Your Honor, I have a preliminary matter, though. Yes.
Okay, we can address that in a minute. Defense is ready.
Yes, Your Honor.
Your matter?
Your Honor, counsel spent quite a bit of time arguing about a polygraph, but as the court knows, if Mr. Wright had taken a polygraph and passed it, it would be absolutely inadmissible, and the state could not present it to this jury. Thus, the argument about the polygraph is absolutely improper as it was phrased and presented, and I asked the court to instruct the jury that had Mr. Wright been given a polygraph and had he passed that polygraph, the state would not be permitted to introduce that evidence in trial. It is inadmissible. And
Your Honor, had he been offered a polygraph, passed the polygraph, I couldn't have made the argument. And so we're dealing with two levels of speculativeness. One, that he was given a polygraph, and two, that he passed the polygraph. I simply spoke about the facts, and the facts were he was never administered a polygraph. That is a fact.
Anything else?
they argued, would they trust him if they'd known he passed a polygraph? Their argument went well beyond where it could be.
Anything else?
No.
Defense, anything else? Obviously, this is going to the jury today. If a penalty phase is necessary, how many days do you need?
1 day, Your Honor.
Defense?
I estimate 1 day, Your Honor.
So 2 days total?
I think at the most, yes. At the most.
Okay. And are we looking at sequestration, or is that going to be waived? Or do you need time to think about it?
I think a little more time to think. Yesterday.
Well, there's two different phases. You're entitled to sequestration at each. You waive for the guilt phase. I'm
Yes.
asking about the penalty phase if we
The
get
same.
there.
The same,
From the state, the same?
yes.
Okay. And you guys want to think about it a
Yes,
little
sir.
bit? Because I've got to factor that in if we get to a penalty phase, when we'll start it, potentially. How much time in between guilt phase and penalty phase? I think we were talking about a day or two.
I think 2 days at the most.
Acceptable?
2, please.
Acceptable? Okay. So if we do that, we probably will start that more likely than not next week then, if we get to that point. If you guys could let me know as soon as you come to a decision on waiving or not. If you have to wait until we have a verdict on this to see if it's necessary, that's fine as well. But the sooner the better, in case we have to organize hotel rooms, things like that, let the jurors know. As far as that goes, and the reason I'm asking this as well is I need to determine what to do with our alternate jurors, because if they're needed, they are alternates for the penalty phase if we get to that point as well, even though they won't be sitting at the guilt phase. So I have to decide when to tell them to come back. So that's another reason I was asking, because it's Wednesday. We're taking a couple days off. I think I will instruct the jurors, the two alternates, to come back Monday morning then at 8:30. Now, of course, if deliberations take days or push into that date, that's just a control date where I can tell them to come back at a later date, but I want them available if needed. Anything with that, State?
Sounds fine to state.
Defense?
It's fine, Your Honor.
Okay. Ready? Oh, wait, I have to roll on your, look. It's fair game to argue it from the defense, but I think it's fair to say it's not admissible if he had taken one, and they can give it whatever weight they think is appropriate. Would you like me to say that, or would you like to say it in your argument?
Pardon me for pausing, Your Honor. So you would
It's
say.
the status of the law that it's not admissible if he had taken it, the results. So do you want to say it or me?
I'd like you to say the status
Okay.
of the law, Your Honor.
Acceptable?
I'd prefer the state just to make it his argument. Again, Judge, this was something that I said in an argument based upon facts that came out in evidence. This was part of our argument. I made no statement as to the status of the law. I made nothing about admissibility or inadmissibility. They can look at the agreement and determine the instances in which it would be admissible, and that would be in a trial against Mr. Wright.
It's only in very limited circumstances. Yeah, that's correct. Okay. I'll make a brief statement on it, and your objections noted for the record. Otherwise, everything, you ready?
Yeah, I'd like to approach the clerk for one more exhibit,
Sure.
Your Honor. I just.
We'll deal with the videotaping issue at the end after instructions. Bring them out. Sir. Please be seated. I'll ask our jurors again, have you followed my instructions, not talked about the case among yourselves with anybody else or looked up any of the people or places involved? Even if you did so inadvertently, now would be the time to raise your hand and let me know. For the record, no jurors lifted their hand. If Mr. Wright had actually taken a polygraph, those results, if he had passed, would not have been admissible during this trial. State.
Please report.
Ma'am? Another notepad? Yes, ma'am. Just one moment. State.
Thank you, Your Honor. But for Mark Sievers, Teresa Sievers would not have been found dead on her kitchen floor in a pool of blood. But for Mark Sievers, a brutal homicide would not have occurred. But for Mark Sievers. Mark Sievers is the catalyst. Mark Sievers is the cause. Mark Sievers is responsible for Teresa Sievers' brutal murder, and he should be held so accountable. How much is a human life worth? Most never even.
Objection, Your Honor, improper.
Sustained.
What was Mark Sievers willing to be the catalyst? What made him willing to sit there and be the cause of Teresa Sievers' death? A minimum of $275,000 a year.
Objection, facts not in evidence.
Overruled.
Maybe even $550,000 a year. That's the annual income. That doesn't include the ability to go into the trust and into the principal. And that trust document is in evidence, ladies and gentlemen. It doesn't matter when the trust was made. It doesn't matter the year or the purpose for when it was made. What matters is that it is. And as it is and was, Mark Sievers was the beneficiary, Mark Sievers was the trustee, and after his board-certified attorney had made clear, the entire income would have to be taken out every year. The testimony of Curtis Wayne Wright alone, with no other evidence establishes every element of the crime of first-degree murder and establishes every element of the crime of conspiracy. The testimony of Curtis Wayne Wright alone can be sufficient to convict Mark Sievers. But counsel has argued you should not believe Curtis Wayne Wright. He is a 5-time convicted felon. He has bipolar and whatever else was said. And certainly the court will instruct you that those are factors to consider. And when you consider those factors, consider this as well. Mark Sievers had Curtis Wayne Wright at his wedding to Teresa Sievers. Mark Sievers went to Missouri with his girls to see Curtis Wayne Wright. Mark Sievers had Curtis Wayne Wright work on the computers in the medical practice. Mark Sievers flew to stand by the side of Curtis Wayne Wright at his wedding. And that text that so much has been talked about has Mark Sievers taking the girls out to Missouri in the summer to visit Curtis Wayne Wright. It says a lot about Curtis Wayne Wright. The court will also instruct you that one of those factors to consider is whether a witness has the opportunity to see or to know. When you hire someone to murder your wife, the person with the best opportunity to see and to know is the person you hired. Mr. Hunter went through with you extensively the amount of evidence that supports, affirms, confirms Curtis Wayne Wright's testimony, and he went through it in detail. Defense counsel says that the only evidence of the conspiracy is the testimony of Curtis Wayne Wright. No. The evidence of the conspiracy also exists within the records and the phones and that information that you received in this trial. And it is to that right now I want to speak. Just a moment. As counsel said, you will have all of these exhibits back with you that you can look at. But let me take you through 3 items or 3 areas I want you to pay, the state asked you to pay special attention to. State's Exhibit 104 is the phone log between 404 and 858. Remember, 404 was the Georgia area code, 858 the California area code. And Myra Simmons spoke about this in her testimony. State's Exhibit 104. Now, at 6:25, we'll start with at 6:25. So if you look at, you have to pardon me, let me hold it further away. It's at the very bottom. At 6:25 on this exhibit 104, you will see that at 8:10 p.m. there is a call between 404 and 858. When you look at this exhibit, states 104 for 6:25, you will see that at 8:10 p.m. there's a call between these 2 burner phones. And if you take Defense Exhibit 2 and you turn to page 38 on Defense Exhibit 2, you will see this. And remember that Defense Exhibit 2 is a timeline that was a Cellbrite report that was made from the phone record, the phone download of Mark Sievers' phone. There is a text in this download on 6/25 at 8:01:14 from Mark Sievers to Curtis Wayne Wright, and it says just 5 minutes. And Curtis Wayne Wright responds to Mark Sievers with the simple letter of the alphabet, K. Okay, I think, K for short. At 8:08:53, Mark Sievers texts Curtis Wayne Wright and says, "Call when ready." And at 8:10 p.m., a minute later, there's a call between those two phones, the 404 and the 858. Let's go back to State's Exhibit 104. And again, you will have 104 in the jury room. State's Exhibit 104, if you go to 517, which is at the top of the chart, let's talk about, because we're going to talk about 517, let's go to page 32 now of Defense Exhibit 2. Page 32 of Defense Exhibit 2. At 6:47 and 28, Curtis Wayne Wright sends a text to Mark Sievers, and it says, "Check other." And at 8:11:52, Mark Sievers responds to Curtis Wayne Wright, "Hello, brother, from a," in quote, "other," close quote, "mother." And the log that you see on 104 shows a text message at 8:11 and then shows a phone call at 8:16. Let's talk about 522, the date, May 22nd. And let's just look at page 34 of Defense Exhibit 2. Defense Exhibit 2, page 34, at 8:50 and 35 seconds, Mark Sievers texts Curtis Wayne Wright, "Do you think we could talk a little tonight? Just need 3 minutes." Talks about setting up a static IP T-home, put in quotes the word other, close quote, then changing. And at 8:58 and 19 seconds, Curtis Wayne Wright texts Mark Sievers and says, "Call me in 5 minutes." And at 9:04:42, Curtis Wayne Wright says to Mark Sievers, "5 more." At 9:25:20, Mark Sievers says to Curtis Wayne Wright, "Now okay?" At 9:26, Curtis Wayne Wright texts Mark Sievers, "Yep." And on 5:22, when you look at the phone record, you see that at 9:29, the 404 and the 858 number communicate. It is not the testimony of Curtis Wayne Wright alone that proves the conspiracy in this case, though it is sufficient to prove the conspiracy in this case. But it is not that testimony alone. It is the phone records. It is the Cellbrite download. It is the independent information that Mr. Hunter so well put that has no motive at all. It just is the facts of this case. Even the personal cells speak worlds. As Mr. Hunter showed, and you will have this as an exhibit to take back, State's Exhibit 118. It shows how there are the calls on June 24th, the calls and texts on June 25th, and June 26th, and June 27th. And then nothing on June 28th, and nothing on June 29th. State's Exhibit 118. The records that have been introduced into evidence show that the 404 number was activated on May 17th, and its last ping, its last time any cell tower picked up its location, was 6:29, and it went radio silent. The 858 number, what's in evidence? It shows that on May 7th, that 858 number was activated, and the last time it ever pinged on a cell tower, the last time it was ever heard from, was June 26th at 1:24 p.m., the day that Mark Sievers, Teresa Sievers, and children flew out of town. Much has been made about the idea of a burner phone. We can call them prepaid phones. We can call them anonymous phones. Why have some prepaid phones gotten the name burner phone? You know, it may come from our concept of burning through money that we talk about, or money going up in smoke. That idea of spending something that is very short-term. And for that, burner phones, when they are purchased for a very short, prepaid anonymous phones, when they're purchased for a very short period of time, have been given the name burner phone. The idea of spending money for a phone that you use for just a short period of time. Call it a burner phone, call it an anonymous phone. These phones had no name, no user, no purchaser attached with them. You know, the defense has asked you to disregard the cell phones, to disregard the testimony of Myra Simmons, to disregard the evidence before you. And
Objection to this statement.
And has asked that you consider that Angie Wright is somehow involved in this homicide. Because there's a 702 number that became active on June 28th and stopped being active sometime the end of July or August. And that was introduced as one of the state's exhibits. You heard from Myra Simmons regarding that 702 number. When it popped up initially with the 404, she asked the detectives to get the records for it, but when the records arrived, it was so clear that that phone was not a part of what had been going on that there was no need to further examine it. But law enforcement did get the records of the 702 number. They didn't fail to thoroughly look into what was going on. What they did is put aside that which was not of any value in determining who had murdered Teresa Sievers. some of the slides, and these will all go back with you in evidence that Myra Simmons spoke with you about, speak to a lot of this. State's Exhibit 100 shows you the California phone, the 858 phone, where it activated on May 7th, where it activated on the tower closest to the Walmart, and it includes the times that it was activated. And State's 101, it shows you Mark Sievers' personal cell phone pinging off of that same tower on that same day, just minutes apart. And if you'll recall, during Myra Simmons' testimony, she had an activated slide that allowed you to see the order and the pinging of those phones. Oh, I need one more.
Madam Clerk, could I also have Defense 8, please?
Defense 8 as in 8. You heard from Myra Simmons when defense showed her this particular slide, and it's Defense 8, if you want to relook at it. And she told you that the phone of Angela Wright never left Missouri. But what she also showed you in her testimony when she testified is that the 404 number did. And State's Exhibit 102, you can review when you're deliberating. But there are two particular, I don't know if maybe all of these, particularly the state asks you to review, but I want to talk about 103 and 105. 103 shows the 404 and the 858 phones pinging off towers at 8:16 p.m. Those two phones communicating. It is a visual, it's an opportunity to visually see what was going on in those call logs and with those phones. And State's Exhibit 105 talked about how the first ping of that 858 burner phone, that 85 burner phone that came online right beside Mark Sievers' personal cell. This exhibit shows, Myra Simmons told you about it, that 858 number only pinged in Southwest Florida. It only pinged on towers where Mark Sievers' personal cell was pinging. So when you looked, as she told you, at the red dots, right? That's Mark Sievers' personal cell. There's no burner on. But you see no blue dots independent of the red. Why? Because every time Mark Sievers' personal cell, every time the 858 prepaid anonymous burner phone pinged, Mark Sievers' personal cell pinged on the same tower. And that 858 burner phone, that 858 prepaid anonymous phone, never left Southwest Florida. Never left Southwest Florida. You know, ladies and gentlemen, sometimes it is the small details that provide us as much information as the large. It's the little things that sometimes give us that common sense view of what's going on. Defense Exhibit Number 6, the shredded policy of the Metropolitan Life Insurance Company, which they introduced the agreement for. When you look at it, and please do, look at all the exhibits. It shows a policy number on it. And yes, it talks about the Metropolitan Life Insurance Company and a policy number. And then within it, it does talk about disability insurance. Found shredded in the office of Mark Sievers. There wasn't going to be any need to have disability insurance for Teresa Sievers. She wasn't going to be alive after the end of June, after the end of June. Small details. When you listen to the voicemail that Mark Sievers left for Dr. Petritis, and we all listened to it, in that voicemail, he gives Dr. Petritis the garage entry code, 1313. And defense counsel says, well, you know, why wouldn't Curtis Wayne Wright have the garage entry code? I mean, he's been down to visit a few times. You heard Dr. Petritis testify that they were over and watched pets. He didn't have that code. Curtis Wayne Wright did not have that code. Mark Sievers had to give it to him. Dr. Petritis did not have the code. Mark Sievers had to give it to him. That's one small detail. Let's talk about the second small detail. Mark Sievers called Dr. Petritis and asked him to go check on his wife. And then gave him the code to enter in through the garage to check on her. What else do we know? We know that it was a house that had guns, that there were guns all around with ammunition. We know from the testimony that Teresa Sievers did not like being alone and got scared. In fact, one time she called Dr. Petritis to come over because she was worried. And Mark Sievers tells him not to knock on the front door, but to go in through the garage with a garage code. If you don't know he's coming over, what does a person tend to do when they're nervous and there's guns in the house? Mark Sievers knew it was fine to give him the garage code and tell him to go in through the garage. Why? Because Teresa Sievers wouldn't be firing any shots at Dr. Petritis. Teresa Sievers was dead. Defense says that we need to disregard the testimony of Curtis Wayne Wright, that he's not credible. What's another piece of common sense to look at here? Mark Sievers and Jimmy Ray Rodgers drove from Missouri through the night to murder Teresa Sievers, take nothing from the house, have no personal gain, and then return back to Missouri? That defies common sense. This was not a crime that was committed for no reason. Mr. Hunter said to you, ask yourself why. It is the question of this case, why? Why is Teresa Sievers dead in the middle of her kitchen floor in a pool of blood when nothing is taken from the house? Because, as the text messages make clear, as Curtis Wayne Wright makes clear, this was a murder for which it was a murder for hire. There was a payment for this. that payment was to come 3 months later when the life insurance would come in. And while it should have been taken, it was supposed to be made to look like a burglary, and why didn't it? I suppose what Curtis Wayne Wright tells us is that after it, they just ran out. But what else does the evidence tell us? It tells us that Curtis Wayne Wright didn't purchase that burner phone until May 17th. He told us he needed somebody else to do this with him. He talked about trying to talk Mark Sievers out of this. And what does hanging around a motorcycle tell us? What does all of this tell us? What makes sense out of all of this? Perhaps second thoughts, not wanting to do it, dragging your feet, hoping Jimmy Ray Rodgers will take care of it. Common sense, ladies and gentlemen, is probably one of the most important items you get to take with you into the jury room. There's so much you don't get to take with you, but you do get to take your common sense. The state must prove to you the murder of Teresa Sievers and who committed that, for you to consider the evidence in terms of the charge of first-degree murder. So the evidence that has been presented to you regarding Curtis Wayne Wright and Jimmy Ray Rodgers traveling to Florida is because the state must present to you evidence to establish the murder of Teresa Sievers and who did it to support the charge that's in the indictment. And so, ladies and gentlemen, it is not the state presenting evidence for any purpose other than to establish the facts in this case and to meet the elements that the state is required to meet. Counsel talks about there's no evidence of two hammers. When you're in the back, if you choose, you may look at the autopsy photos. They're in evidence. And one of them will show you a ring of blunt force trauma around Teresa Sievers' head, as well as trauma on multiple locations on her head. The evidence supports the allegation that two people were murdering Teresa Sievers. Let's touch on the plea agreement that was entered into by Mr. Wright. Please feel free to read it. And when you do, read paragraph 9E. Mr. Wright is subject to a polygraph up to the day he is sentenced under this plea agreement. Up to the day he is sentenced. And should he fail that polygraph up to the day he is sentenced, his agreement goes away. You know, in opening, we talked a bit about a puzzle and the puzzle pieces. And Mr. Hunter showed you the puzzle pieces here. But for any who have actually put a puzzle together, a jigsaw puzzle with all of the pieces, they realize that you don't need every single piece filled in, every little corner completed to see the picture. And certainly in this case, the picture is absolutely clear. You've just listened to, and I'm not going to keep you much longer, a great deal of argument from counsel about what the evidence is, what it said, what you should consider. Ladies and gentlemen, it is to you and you alone for you to determine what the evidence was. It is to your recollection and your recollection alone to determine what was said in this court by the various witnesses. And to you alone to determine
what evidence is credible and what evidence is believable. It is not what I say. It is not what Mr. Hunter says. It is not what Mr. Mummert says. Rely on your collective memory when you reflect back and consider the evidence in this case. You saw each of the witnesses come in. You saw Taylor Showmaker, who 5 months after this makes a call and is now and has started receiving $400 a month. You can determine whether or not you're going to choose to find her credible or not. But what is a fact is that that blue jumpsuit that was found on the side of the road that she was able to take detectives to, that blue jumpsuit had fibers on it. And those fibers, you heard what Linda Otterstader said, those fibers, what did she say so carefully and with precise language? The fibers from the blue jumpsuit and the fibers found on the tape lift and the dress of Teresa Sievers had all the indicia of coming from the same item. Amazing that Taylor Showmaker could take law enforcement to a jumpsuit on the side of the road, and those fibers would end up having all the indicia of the fibers from the tape lift of Teresa Sievers. And how much more so that a hair, a tiny piece of hair from the head of Jimmy Ray Rodgers would be on that jumpsuit. Ladies and gentlemen, the evidence is absolutely compelling. That blue jumpsuit was worn, it was held, it was in the possession of, and it was worn by Jimmy Ray Rodgers. And when you couple it with Curtis Wayne Wright's explanation for how they could go into a home and a brutal murder be committed, and there not be one fingerprint, one piece of DNA left in the house. That jumpsuit, those jumpsuits provide the answer. And the argument that there should have been traced both ways in terms of the car, you know, they found these fibers but didn't find blood. Well, if you take the suits off before you get in the car, you're not going to have all of that. But remember, the suits were in the car coming down as well. You know, there are many pieces, and I don't want to focus you just on certain pieces of evidence. Please look at all of the evidence that's been introduced. You'll find that State introduced 25A, which include calls as well as texts between Mark Sievers and Curtis Wayne Wright. Please take the time to thoroughly consider the evidence, because the state is confident that when you do, when you use your common sense, when you look at the hard evidence in this case, when you consider the cell records, both the text messages that you heard with the coded language, when you look at the burner phones, the 404 and the 858, and you see how they line up, when you consider all the evidence, that you will reach the only conclusion supported by the evidence. That is that Mark Sievers is guilty of the premeditated murder of Teresa Sievers. He was responsible for setting it in motion. He agreed to pay for it. He knew it was happening. He participated in it. And Mark Sievers is guilty of conspiracy, which, as Mr. Hunter said, doesn't require that the murder ever have been completed, though it was. But in that arranging for it, in that conspiring with Mr. Wright, With Mr. Wright then bringing in Mr. Rodgers, he is guilty of conspiracy, and the state asks you to so find him. Thank you.